Sound check 1 2 1 2. Sound check 1 2.
Before I do that, maybe just to request the people that are in this row to kindly move this other side so that we don't give the people on the media side some hard time, because this is actually a stumbling block. So we just move this other side so that we retain that place for any other person that comes late. I'm sorry for that. Just this row. You okay, Dan? As I said, my name is Augustus, and I take this opportunity to welcome all of us to the very first LSAC, that is the Law Student Association of Kenya event. This afternoon it will be like a public lecture that is meant to ensure that our persuasive skills as far as practice of law is are enhanced and sharpened. So let me take this noble opportunity to welcome all of us and ask Habonaya to open this meeting with a word of prayer. Kindly.
Good afternoon. Okay, let's pray. Dear everlasting Father, to whom all hearts are open and all desires known, as we have gathered here this afternoon, be with us, O God, as we start this meeting. Jesus, bless our staff, our each and every student that is present here, O God, as well as our chief guest, Council Lillian, O God. Whatever that we are going to learn here today, Jesus, Lord, may you be with us. And whatever, oh God, that is supposed to sink in us, Jehovah, may you be with us, King of all glory. As we embark on this wonderful lesson, Jehovah, we pray, God, that you may give us knowledge and understanding, King of all glory. And whatever is going to be taught here, Jehovah, may we be able to implement it in our studies, oh God. Let your wisdom guide us even in our studies. In the mighty name of Jesus, we do pray. Amen.
Thank you, Habonaya. That was good. Just to begin by a way of introduction, allow me to recognize the groups that are here, or the different cohorts that are here. I'll begin with the first year class. In case you are in first year, let's just stand up on our feet. We recognize you. Any first year student, just be on your feet. I'm not going to ask you to come in front to speak. Just be on your feet. Wow, that's awesome. That's awesome. Although the numbers are still very low, you can take the opportunity to text in your WhatsApp wall to ask they that are not here with us just to join, because I believe you are around 40 or 38 there. So that's a good number. You may be seated. The second year cohort. And you know, Dr. is here, is assessing the number, the people that are not coming. Second year, that is awesome. Can we appreciate them? Okay, thank you. You may be seated. Can we appreciate the first years? I'm sure we didn't appreciate them. The third year students. They call themselves elders, but they're not. Okay. That's a good number. Can we appreciate them? Finally, the finalist class, that is the fourth year, the elders, wazee wenyewe. Can we be on our feet kindly? Yeah, majority of them probably I'm interacting with them for the very first time. Nona, wazee, that's awesome. Oh, there is a lady. The gents are very many. What is happening, Mlanda, with the ladies in your class? Okay, that's awesome. Thank you. We are very happy that you took this personal initiative this afternoon to join us. And without wasting much time, let me take this opportunity to welcome Mlanda, who will then introduce the LSAC officials and also take us through the objectives of the LSAC Society. shortly. Welcome.
Good afternoon, everyone. First of all, before I explain what LSAC is, kindly allow me to thank Dr. Mwanakitina Bakari for being able to allow us this opportunity to have this event. Also, I extend my appreciation to Dr. Sarah and also to Council Lillian at any time, because those of us who understand behind the scene, we were all unanimous that it's her who should come over to train us. And when we communicated the message to her, there was no second thought. She fully agreed. I also would like to, when I remember 2 years ago when we were doing such a lesson under Dr. Mwanakitina, something really nice happened, because for us, those of us in fourth year, we will never forget the fact that during our cut, Dr. Bakari actually gave us one-on-one feedback, and that's very rare. So we really, really were able to learn a lot, our weaknesses, our strengths from our cuts. And also, during cross-examination, re-examination, and examination in chief, that is delivering the cause of evidence in evidence law, it was one of the best lessons. And I think Council Lillian will agree with me, because when Fatma was walking in, she impressed on the same. So I still remember the beautiful flowers that I got from answering 2 questions right here in class. And those were beautiful memories. But when I went to do my attachment I was stationed at the High Court, Mombasa Law Courts, what the judge told me, and this was Justice Magare Kizito, that the first Bible for every lawyer is the Constitution, the second one is the Evidence Act. So it is very important. And I wouldn't be more grateful to have Dr. Mwanakitina Bakari with us today, and also Council Lillian to take us through this. So thank you so much. Additional to that, I would like to introduce you to this Law Students Association of Kenya. At the moment, we have a number of officials who are here. Okay. My name is Thomas Mlanda, final year student. I'm the chairperson of the Law Students Association of Kenya. I am deputized by Jasmine Nyaga, who is not here today. She's a second year student. And then we have Dan Mwangala. Please, Dan, stand up. Dan is our Secretary General. Thank you so much, Dan. We also have Stephanie Habonaya, who is the second year representative. Stephanie, please stand up. And then finally, we have Stacy, the first year representative, who is not able to be present today. We also work very closely because we are a team, and we would want to have as much as possible impact on the student by being able to create such academic events and so many other things that can make us learn and transform and have a lot of impact on us. And I really appreciate the fact that every time we come up with these our ideas, our administration is always ready to give us a go-ahead. So we do appreciate that. And more will be coming apart from this. So we would like to open it up so that we can have ideas from everyone. And please, let's feel free to engage and learn as much as possible. Thank you so much, Titus. You can take over.
Can you appreciate Mlanda? Yeah, maybe one of the things that he has not mentioned is that LSAC is an association of law students. And that is to imply that everybody that is here is a law student or is a law practitioner, because these other side, they are not students. Those are advocates, right? So LSAC brings their students together to ensure that we advance the issues of the students' welfare, and also ensure that we get the skills that are needed in the practice of law. And among the things that we intend to do is, as Mlanda had said, we intend to have events like this, learning experiences that are other than what we get in class. We get people that are actually practicing, sharing with us. We also intend to organize moot courts in conjunction. We also organize moot courts in conjunction with the Moot Society, and also we work together with Sala on issues legal aid. So that is, in a nutshell, what LSAC is meant to do. We are replacing what we used to call KLSS. For they that are very old in school, the seniors understand this. So we are actually coming back to ensure that law students' needs are well taken care of. We have the media team. I'm wondering, people are asking, and where is this media from? So this is courtesy of Reverend. This is courtesy of Father Bosco. Can we appreciate them? Thank you. Without wasting much time, allow me to take this opportunity to welcome Dr. Monakitina Bakari to give her remarks and in turn invite the guest who will be taking us through the theme of the day. How many are familiar with the theme of the day? Anybody who knows the theme of the day? You can just be up on your feet and then you project it. Ahmed? Okay, you can say it louder.
Strategies for efficient oral transmission. Okay. How to make oral submissions in court.
Paraphrase. That was excellent. Dr. You're welcome. Let's appreciate her as she comes.
Good afternoon, everyone. Today is not my day to speak. You'll see me. I saw some of you in class yesterday, so I'll be seeing you later in class. So, but today I think it's a privilege for us to have such opportunities for you to get exposed to different methodologies of learning. So, as always, Madam Lillian is very gracious enough to always accept our invitation whenever we call upon her. And being a trial advocacy teacher, yeah? Trainer, what are you? TOT, everything, eh? Yeah, she's a part of the trial advocacy, which I also went through some many years ago. She will tell you when I started, I was very timid, too scared to talk to people. But thanks to the training, I think I built my confidence, and I'm happy to. I'm glad to say that it was very beneficial for me. So without much further ado, let's give a round of applause to Advocate Lillian so that we can start the program. Welcome.
Good afternoon. I want us to start in a very different way or unique way. I'm not going to ask you your names, but I just want to learn from each one of you. What do you want to learn today? Just tell me one thing. What do you want to learn today? Start from there. Can you hear him? We're going to do something. If you can't hear someone, you just say objection. Okay?
Yes. Okay. Thank you very much. I want to learn more about advocacy. Basically, oral presentations in court.
Good afternoon, everyone. Yeah, I'm a first year, so I would just love to learn the communication skills for lawyers and the theme of today also. Thank you.
That's an objection? Okay. Okay. You can go after him. Just say yours and then he'll go after you.
Hi, everyone. Based on the theme, I'll like to learn about the oral presentation.
Thank you. You can go ahead. Go ahead, please. I'd like to learn how oral submissions are done in court, how am I Anyone else? Yes, please go ahead.
Good afternoon. I want to learn about the court processes, especially during the hearings and presentations. Thank you very much. I'm Nick.
We have two more people because of time. We can't have all of you, I'm told. So two more people, gentleman and a lady. Who wants to volunteer? We have the lady. Go ahead.
Okay, I'd like to learn about more of the advocacy skills and how to present my oral submissions. Thank you.
Hello. So today I'd like to learn about persuasion and especially something to do about building a theme. Oh, here I am. Yes, exactly. There's a time during the moot court you talked about building a theme. So that's what I came for here today.
Your theme is oral submission, but I noted your main theme is persuasion, right? Mastering the art of persuasion. What is persuasion? Who knows what persuasion is? To persuade, what does it mean? What does it mean to persuade? Yes, go ahead.
Persuasion is the art of convincing someone to buy your idea.
Correct. That's very correct. Convincing. And that's what the trial process is all about. You convincing the JO, or rather the judicial officer, to buy into that story that you're telling the judicial officer, to buy into the story of your client. And you don't just persuade during submissions. Submissions is the last resort. If you're not able to persuade from the first time that you start, then you'll not be able to persuade even during submissions. So we'll touch a bit on what leads us to submissions before we go to submission, okay? So at what point do you start the art of persuasion? You start it in your chambers. When the client walks in, that's when you start. And one of the things that you must have is a skill known as listening. And this is a skill you'll use throughout, from your chambers until your last word in submission. Listening. Listen to your client. Listen to their story. And don't just be a passive listener. Take notes. Write your client's story down. And this is something also during the court process or the trial you have to do. Don't just sit there. Always take down notes. Always take down what the other counsel is saying. Take down what the judge is saying. Why do we do this? One is to get clarity. This is not your story. This is your client's story. You need clarity. If you don't have that clarity, you'll not be able to persuade when you're in court. And you follow it up with questions. When a client is saying a story, something is not clear, ask questions so that you can understand. Even the most difficult question, ask them for you to understand. You are strategizing on how you're going to argue your case by asking those questions. And you write down the answers. Does it make sense or does it not? Is it a weak point that you need to look for ways of working on that weak point? You write it down. So again, when you're writing down, don't just write the good facts. Don't just love how your client's story looks so strong and you're forgetting about some of the weaknesses of your client's case. Write down the bad points. Remember that the bad points are the good points for your opponent. So what you're doing in your chambers when you're with your client is what is known as case analysis. You're analyzing the case. And from there, you'll be able to know what this case is about. Is it about negligence? Is it a murder case? Is it a corruption case? Once you identify what type of case it is, then what are the ingredients for proving that that is what the case is all about? What are the ingredients for convincing or persuading the judge that your client needs to win? And like what our friend, please remind me your name? Jambo. Like what Jambo said, theme. It's during case analysis that you're able to identify what theme your case is all about. Just the way I said it, what your case is all about, that's the theme. And why is it important to have a theme? It's important to have a theme because when you start the trial process, the first time that you stand before the judge and you start with your submission, with your opening statement, you are required to tell the court what your case is all about. If you don't tell the court that, sometimes the court might not even be interested in your case. And it must be an interesting theme for the court to look forward to listening to what you're about to say or what you're supposed to, or what you're about to submit on. So it's really important to have that theme of your case. And in our system, in the Kenyan system, you all know, we don't do trial day by day. You're not given a day today, and then the next day you follow up with a hearing on that. No. You can be given a date today, you do your hearing, and you're given a date even next year. So if you don't impress the judge, if you don't have an interesting theme, the next time you'll be coming, they're not even remembering what your case is all about. And they might not even be looking forward to hearing your case. But you leave the judge with an interesting theme that, in fact, that can persuade them to give you a nearer date because they're interested in this theme. Like the O.J. Simpson case. Who knows about that? Who has heard of it? Do you remember what the theme was? What was the theme? Exactly. And that is how the advocate started. And from the beginning, even during examination in chief, all the questions that they were asking were along that line until they finished. And that was their last word in the submissions, their theme. So you identify that during case analysis. And apart from the theme, you also identify what is known as a theory during case analysis. What is a theory? So you've identified your theme. This is what this case is all about. But how does it fit into the law? These are the facts that the clients have given you. How do those facts fit into the law? So a theory is what explains how your case fits into the law. Say I was negligent. Do you have facts to prove that this person was negligent? So you look for facts that will fit into the law. So once you do this during case analysis and you've identified good facts, bad facts, you've identified your theme, you've identified your theory, then you get ready to start the persuasion. What do you do with the bad facts? There are bad facts that you've seen. What do you do with them? Do you ignore them? Some people may ignore. Please, just go ahead and just remind me your name. You try to come up with possible solutions. Yes. Bad facts, some people ignore them, some people acknowledge them, and some people give an explanation like what you say, justify them. So you as an advocate or a lawyer, you decide you want to take option 1, option 2, or option 3. Me as Lillian, I always go for option 3. I don't just acknowledge, but I look for an explanation. I look for justification. And sometimes you actually change them into your good facts. You find a way of turning them to favor your client. That way you'll be able to persuade. And that is what is known as judo law. So now you have all that. Then you draft your pleadings. going to court. You lose a case. Most of the times we lose cases in our chambers. Even before you go to court, you not even get a chance to persuade because your pleadings are so pathetic. So how you draft your pleadings is also important, and the art of persuasion also goes there. Draft your pleadings in an organized manner. And your pleadings are about facts. Bring out all those facts. Don't have a bundle like 20 pages or 30 pages of a plaint. Who will read that? So be brief. Don't use law jargon when you're drafting your pleadings. Even if it's going to the judge, don't do that. And this is more so when you're doing witness statements, which we do these days in our courts. This is a statement by your client. Your client is a layman. Why do you want to put law jargon there? And do you want it to flow? Of course, you want it to flow. An organization that is not flowing will not persuade anyone. You see, sometimes advocates go to court and we have you have your file, you're trying to convince the judge, you're opening to check where you want. That is not organization. So this also goes into your pleadings. Be organized. When you're organized, by the way, you won't be doing that in court. It will be easier for you. So you've drafted your pleadings. Of course, it goes automatically. The other side will draft theirs. They will file their defense if they are filing. And then the first time that you are going to court, the persuasion continues. Opening statement. Well, you'll find that in most of our courts, you'll not find people doing opening statement. But I expect all of us here, when you start practicing, you'll be doing opening statement. No one will stop you, by the way. Even if a court, you find that in that court, no one is doing opening statement. You ask a magistrate or a judge to do an opening statement, they will allow you. And believe me, an opening statement helps you. So to ignore it might be detrimental to you. Because an opening statement helps you, reminds you what your case is all about and what you're going to bring into court to prove that the case is all about that theme that you have advanced to the judge. And it can take less than 2 minutes in doing an opening statement. So what do you do during an opening statement? Someone wants to try? I'll choose someone else. Dan, thank you.
In an opening statement, you can come up with you can begin by giving a theme to what your case is all about. Then you go ahead and give a theory of your case. So let's say you're doing a criminal case. So you can start by giving a small theme of the case, then go ahead and give a theory of the case so that to give the JO a chance and to know what you are going to bring in court. Yeah, thank you.
Thank you, Dan. And what Dan is saying, in your opening statement, tell the court what your story is about, theme. Briefly, explain to the court how the facts of your case fit into the law, theory. Apart from that, tell an effective factual story of the case during the opening statement. And not to forget to use a persuasive theme when you're doing your opening statement. And of course, organization of your opening statement needs to be very well organized. And then, the other name for an opening statement is a promise. And we all know, if I promise you something, I must deliver it. Don't promise what you can't deliver. So you tell me the case is about this. I will prove to you the case is about this. I will bring this to show you that this is what the case is all about. The other side is saying that they have this and this, or they're stating that this is what the position is. I will show you that is not the position. I've promised the judge, so I need to deliver. So if you know you're not going to deliver, don't do that opening statement. So again, you heard me saying, I will show you the other side will do this and this. The other side is saying they have this and this. That's, you remember when I was talking I don't mention it in my opening statement. So once we are done with the opening statement, you've opened your case, the other side have opened their case. You go to examination in chief. What is examination in chief? Remember, we always say the trial process is a storytelling session. You want to say something? Please go ahead. Correct. Thank you. Correct. Examination in chief. Your client telling the story. You helping your client to tell the story. Not you telling the story. He has mentioned leading question. So what kind of questions do you ask then for your client to tell the story? During examination in chief, you ask open-ended questions. Just as the name goes, open. You're opening your client's mouth to say the story. So what kind of question techniques are these? It's what we know as the one husband, the 5 wives. So a husband who has 5 wives, how is that husband? How is that man? Must be very distressed at some point. Must be tired at some point. Can imagine 5 wives, all of them talking at the same time. And of course, he's in an entanglement. So the husband stands for how. Ask your client how. The first wife, what? Where? Why? Which one have I left out? When? And what about this tired and entangled and distressed? What do I mean by that? Tired. Tell us. Entangled. Explain. Distress. Describe. Those are what we call open-ended question. Giving your client a chance to say more, to put more meat into that story. And then try and be brief in your questioning technique. What do I mean by that? 1 fact per question. Don't confuse the client. Where were you and what did you do and how did it affect you? No, those are 3 facts. So 1 fact per question. And then organize your examination in chief in chapters. You find that a case, there are so many issues that are supposed to be resolved. Categorize those issues in chapters. For example, I was talking about a marriage. Have a chapter about the marital status of this person. Have a chapter about where this person is staying. Have another chapter about the children. So you separate them in chapters. It comes easier to persuade when you have that kind of organization. Because even when the judge or the magistrate retires back to write your judgment, they might decide today I'll pull out all my cases. Imagine I'm a judge. I'm pulling out all the cases I have that are pending judgment, and I only want to resolve one issue in all these cases, and it's marriage. So if you've organized that, remember the judge is writing, if you've organized that in chapter, it will be easier for this judge to go to that file in the proceedings and see Lillian had put there marriage. So all these questions are about marriage, so I'll get all my answers on marriage on this. And I deal with it, I go to the next case. When I find that this particular file, this advocate had not arranged their examination in chief or their cross, which I'll come to in chapters, I say, this one I'll do it last. Let me deal with the ones who have organized their work well. So that's another trick about organization. Leading questions, no asking leading question, because you're not testifying. It's the witness testifying. When you lead a witness, that means you testify. And examination in chief is about the witness testifying, the witness telling their story. So a leading question, for example, I cannot ask a witness and tell a witness, so you got married on 10th of December. I'm actually telling the story. And then after that, you went and had a reception at this place. I'm the one telling the story. And when I tell the story, is it persuading? It's not. It's not me to persuade at that point. It's the witness to persuade. I'm an advocate, so I know that if I do this, I'll persuade the judge. But the judge wants the witness to persuade them, not you, because you know all the tricks in the books. So if you start testifying on behalf of your client, in as much as maybe someone will not object, your story will not be convincing to the judge. And if you get a sharp advocate, they will object. And they'll keep on objecting, and it will throw you back. You'll be wondering now what next. Because they're just objecting, leading question, leading question. And that again takes you back to your chambers. Preparation, by the way, write down. And if you practice for 10 or more than 10 years, write down all the questions in your chambers and get ready with that. Don't make the question on the spot. Okay? Then after examination in chief, of course, your witness is then cross-examined. Their opponent will now be using the cross-examining techniques, and it's the opposite. Examination in chief, open-ended. Cross-examination is leading. Because remember, the intention of cross-examination is not just discrediting the witness, but trying to show that whatever the witness has said, that's not the correct position. And you, who is cross-examining, this is the time that it gives you a chance to testify for your witness. So cross-examination, you're the one testifying in a smart way by asking leading question. You don't have a marriage certificate. The person will say, yes, I don't have. You are not there on this specific day. So you know what your client's story is. Now you're seeing your client's story through another person's witness. How persuasive can that be? Another person supporting your client's story. That is what cross-examination in chief is. Aim for that at all points. And then the other rules of examination in chief follows. After the leading questions, organization, organizing chapters, one fact per question. Simple English, no low jargon. And both in examination in chief and cross-examination in chief, always be ready for objections. You know your case. Play the devil's advocate in your chambers. If I was on the other side, what would I object to? So you already know, you anticipate what the other person will object to. Then start looking for answers. Go back to your statute. Go to case law and see how best you can answer to that particular objection. I'll give you an example from experience of a case that I handled some time back. So in this case, there is a letter written by the land registrar to my client. I know the land registrar is not on my side in this case. And I want to produce this particular letter through my client. I knew they would object. So at the point of production, of course, the other side objected because they know, first of all, the RAN registrar is coming in as their witness. So they objected and said, my client is not the author of that particular document. Of course, I went back to the Evidence Act and said that objection is not valid because my client is the recipient of that letter. That means my client is the custodian of that letter. So my client then is entitled to or has an obligation to produce that letter because of those two reasons. But it's an interesting case because as much as I prepared for objection also, I'll not say compromise, but I knew even my objection, my justification will not be allowed even if I knew the law actually supports my argument at that point. So of course still the JO said that my argument was not valid and the letter will not be produced. And that was the letter that was going to make my client win the case. But I had anticipated this because I'd prepared in chambers. So what then did I do? I sought for leave to appeal against that particular ruling of not allowing me. Of course, I was granted leave because it's automatic. Most of you will think that was the end of it. But no, with preparation, it was not the end of it. I then sought for stay of proceedings, pending the appeal being had in the Court of Appeal before we come back. And what did the JO do? Of course, the JO asked the other side, would you want to go for appeal? The JO was on transfer. He had to finish his cases within 2 or 3 days. And the other side said, it's okay, the letter can go in. So preparation is very important. Get ready how you're going to handle. And even if you know that it's not going to be allowed, do you have a right of appeal? Do you have a case law that will support stay? Like in that particular case, if I was told I'm not being granted stay, and then I didn't have a case law that will support. So you must have case law, even you must have all these laws, not just case law, but statute law, when you're going for any hearing that support any bad fact that you think will come your way. That also goes into the art of persuasion. So after cross-examination, what then happens after cross-examination? Re-exam. But is it necessary? Is it necessary to re-examine your witness? It's not. Yes, it's not. And I'll ask the same question again. Is it necessary to cross-examine? Yes, I'll come to that. Thank you for that. So before we go to that re-exam, is it necessary to cross-examine? What are instances where it's not necessary to cross-examine? Correct. It's not a must to cross-examine. So even if you see an advocate not to cross-examine, don't think it's because they don't have question. It's because they didn't see anything destroying their case. So they didn't see, and sometimes also cross-examine, you cross-examine might actually destroy your case, so you might opt not to cross-examine. And then re-exam what I asked, is it necessary? One of you said it's not necessary, it's true. And he also said it might be necessary if your client had given an answer that you know that is not the answer your client ought to have given. The question then is, when do you need to re-examine and how do you re-examine? I apologize for those two facts. We said one fact. So when do you need to re-examine?
Thank you. The fact that it is not necessary to do cross-examination. At this examination in chief stage, if it happens that some information has been presented, which prima facie is falls under the doctrine of res ipsa loquitur, can we say that that is one of the things that can make a lawyer from the other side to decide not to cross-examine? And if so, who decides whether a certain set of facts are res ipsa loquitur? Is it the judge who decides that, or is it the person who spoke having to mention it? Thank you.
So during examination in chief, if you notice, there are facts that speak for themselves. Res ipsa loquitur doctrine. And even at that point, you make a decision. I really don't need to cross-examine on this because this witness has actually supported my case using the facts. But you're the one who has noticed first. You don't need to tell the JO that the fact speaks for themselves. I will not cross-examine. You don't just cross-examine, but during submissions, you bring out that doctrine and submit on how it fits into that doctrine. And then the judge will make a decision at the point of judgment or ruling whether indeed it was valid that the fact speaks for themselves. You clear on that? Okay. So the purpose of re-examination, to repair damaged testimony. 2, to clarify confusing testimony. And 3, explain what could not be explained in cross. Because remember cross, we are using leading. Get a sharp advocate there and he'll just be getting yes or no answer, yes, and he'll not even want this witness to explain anything. And you know some of this yes needs to be qualified or no needs to be qualified. But your client is not given a chance to qualify those yeses or no. So then you are able to do this during re-examination. Then what are the principles of re-examination? Only what was covered in cross. Don't start bringing new things. So listening that we started with. Listen when cross-examination is being done. Remember when I said you prepare in chambers? You write all your questions for examination in chief. You write all your questions for cross-exam. But unfortunately for re-exam, there's only one instance where you can't write the questions that you're going to ask. This is once you've identified your bad facts, and you know that these bad facts might come into cross-examination, then now you write down in your chambers how you're going to re-examine on that. But if they don't come during cross-exam, you won't need those questions that you had written in your chambers. But some of the things might come in cross-exam that you had not anticipated, and now you need to re-exam. So you need to listen and identify what you need to re-examine on. Don't go to your chambers and start writing so many questions. I'll re-examine on this and re-examine on this, and they don't come up during cross-examination. There'll be an objection. Because what you're doing, you are doing examination in chief again. That means the other side will have to cross-examine again on the facts that you brought. You've brought the new facts that you brought in during re-exam. And a JO might not allow that. It's not even allowed. Only in very special circumstances that the JO may reconsider that. So we need to really at all points avoid bringing in new issues in re-examination. Then after re-examination, all the witness, that process, we've done all that. During all this process, examination in chief, cross-exam and re-exam, these questions that you're asking, the organization structure that you've used, and all the techniques that you've used to ask these questions, there's one thing that need to play from beginning up to the end. Your theme. Never forget that. Don't forget your theme. Don't do it in an opening statement and you forget all about it. Show the court through your questioning technique, through the answers that your client gives or the other side gives during cross, that indeed that case is about the theme that you gave. That indeed the facts of that case fits within the law that you quoted, you'll be able to show the court. So don't forget that. Don't bring in a new theme and start asking questions that supports another theme that you had not mentioned in your opening statement. Then now we've closed and we go to submissions. Everybody has closed their case and we go to submissions. So what are submissions? Someone will want to try that? Yes. What should we consider when doing closing remarks? Closing remark in this case, you mean submissions. Your closing submissions. Okay. That's what we are getting into right now. So submissions, or rather the closing remarks, yes?
That's what you give in closing statement.
One of the things that you do in closing submissions is prayers. What else? Yes, please, Thomas.
Under the closing statement or closing submissions, one of the things that you are asking the court is that if the judge is to analyze correctly the facts and the law, then they will find the court in your favor. They will find the case in your favor.
Correct. In simple terms, it's a summary. You've gone through the trial process. You brought in witnesses who have brought in evidence, but we now need to summarize, to convince, or to persuade, as Thomas has said it, so that the judge can rule in favor of our client. So submissions are basically the story of the trial. Remember I said it's a storytelling session? So submission becomes the story of the whole trial. So what you're supposed to do is persuasively articulate your theory of the case. How does the facts of the law, how does the facts fit into the law, fits into the law so that your client wins? You do that during submissions also. Theory of the case, don't forget that when you're doing that. Then always use a moral theme. What do I mean by a moral theme? Who thinks a moral theme, what a moral theme is? Someone wants to try or give me an example of a moral theme? I like the way you're giving the microphone. Okay, choose the person who will give us.
No.
Okay.
I would like to state that I'm not familiar with that.
No problem. Yes, you want to try? Okay.
May just the best case win, and may righteous always prevail, whatever the circumstance of the case.
That's a theme. That's a theme, and it's a good theme. I just want to challenge you. Can you make it brief? Remember the trial process. We try to be brief, simple. You want to try making it brief?
Whatever happens in the case, may justice prevail.
Okay. So in simple terms, as I said, it's the reason the case is in court and why a party should win. Remember when I say how our system is, where you're given a hearing today and the next hearing maybe in 2 or 3 months, and the judge might forget? So again, I will say, in submissions, remind the court your theme, so they don't forget that this case, all this time, was about this particular theme. And then during submission, show knowledge of the law. And how do you do this? Argue the law effectively. What is the law that supports your case? Argue it effectively. Appropriately cite authorities, if you've used authorities. Acknowledge opposing authority. If the other side has an authority to support their case, acknowledge it by either distinguishing it or you argue the change in law. And I think I saw very good submissions from those who are fourth years right now when they had their moot court, where they're able to distinguish. They acknowledge the other side's authority. They know that authority is not in the favor of our case, but they acknowledge it and then they distinguish it. And at some point, they even went ahead. That was very impressive, Dr. Bakari, I must say that. It was very, very impressive when they went ahead and brought out how the law has changed. Like just the example I was given on marriage. Before, there was no registration of customary law, right? Imagine you had a case where someone has not registered their marriage. The law has changed. So you need to remind the judge the law has changed. Even if the other side starts stating that they got married in this year and that marriage was not registered, so it's not recognized, something like that. So you really need to show the judge that. Then again, you use an organized presentation. And that's where the meat is in oral submissions. IRAC. IRAC is, that's something that you will remember always. IRAC to mean issues. When you're doing your submissions, remind the court. Remember I said it's a trial of a story of the trial. From the trial where you're able to bring in witnesses, you're able to bring in evidence. There are 3 or 4 issues that the court needs to determine. Tell the court what the issues are. It's your responsibility to do that. So identify the issues from the trial. That's I. Then the rule. What is the law applicable? What is the law applicable that will help the JO resolve these issues that you've identified? Let the JO know what the law applicable is. Then R, the resolution. How is it resolved? How do you resolve this? How do you resolve these issues? Then, of course, the applicability. Sorry, I must have confused you there. I for issues. The rule is R, the law applicable. And then A is applicability. How do the facts fit into the law? So you're helping the judge resolve those issues that you've raised using the law that you've said is applicable. And then conclusion, which brings in your prayers. So when you're drafting submissions or when you're doing them orally, use the IRAC kind of organization. Are we clear on that? Okay. Then again, during submissions, if there's a chance where you felt there was a witness that was not credible and you argued that through your examination in chief or your cross-examination, don't forget to bring it out again in your submissions. Because remember when the judge goes back, retires to write the judgment or ruling, they use your submissions. They will not go back to what was said. The first thing they do is the submissions. So if you state this was said, and this evidence was brought, of course they will counter-check in the proceeding if it was done. But you must say it first. If you don't put it in your submission, if you don't state it, they might not even go back to the proceeding. So it's important that you state, you bring out that particular issue of credibility in your submissions. So always argue credibility. Then explain why you should win based on the evidence. What I'd explained earlier. Connect the facts in a helpful way to complete the story. Use comparison. Use rhetorical questions. Use repetitive techniques, especially if you're doing oral submissions. Demeanor, if need be, is important. Nonverbal communication, even when you're doing submissions, oral especially, it's very important. Even how you stand is very important. The gestures that you use, very important. Don't use distractive gestures. And be audible when you're doing your submissions. In court, there's no mic. Okay? So that's very important. I'm sorry for that. Just needed to pass the message. Tell the court what you want. Don't do the perfect submissions, following the IRAC rule and bringing out and showing the court how the facts fit into the law, using the best nonverbal communication you can use, and then leaving it at that hanging without telling the court what you want. The prayers you'd put in your plaint, in your petition, mention them. Tell the court these are the prayers, but don't beg. It's the right of your client. You don't need to beg. Just tell the court what your prayers are. You're asking for justice. You're not asking for sympathy. Another thing, evidence. You brought in exhibits. You brought in visual aids, for example. It's your responsibility to remind the court what exhibits you brought in to prove your client's case and how they fit into the law. So again, in submissions, mention all the exhibits and show the court how those exhibits are helpful. And while doing this, don't ever forget those bad facts. Even if there were bad exhibits that didn't support your case, please acknowledge them and justify them during submissions. And when you're doing oral submissions, you can remember it even when someone stops you. If you had prepared from the beginning and if you're passionate about it. And how do you show someone that you're passionate about something? How do you show someone that you believe in what you're saying? How do you show someone that you're confident in what you're saying when you're doing oral submissions? By not using notes. You imagine if I was to do submissions right now, I have my notes here, and I was reading out each and everything that I'm telling you. Would you be believing what I'm saying? You'll just be saying Lillian wrote all this and is reading out each and every word. So when you don't use your notes in court, you're more persuasive. And I'm not saying you cram. You know your case. You can't have your notebook. You have your file, not the headlines. You remember when I was saying chapters? IRAC. You know what the issues are. Just note those headlines. Check. Talk about I. Finish I without looking at the notes. Go to R. Like that. And you'll be more convincing. Okay? And then, lastly, sometimes persuasions is not just about your knowledge of the law. There was this advocate, a well-known advocate, who is always very persuasive in court, passionate about what he does. There's this day he had his matter in court, and he realized he's submitting But it's like the judge was not interested, and the opponent also seemed not to be interested, and even the client. And he did the most unconventional thing. He went into his suitcase, took a lunchbox that had mandazis, and he asked, most of us have been here since morning and we are very hungry. Can we perhaps share this? I promise that I've not poisoned them. Of course, there was laughter. But lucky for him, the judge said, why not? And as they were enjoying this mandazi, the advocate decided to continue with his submissions. And as he was doing this, the judge was stopping and asking questions, and he was clarifying each and every question. The judge is enjoying mandazi, asking questions, and they're writing, and he's writing down. The opponent is not objecting. He's so happy. He's also enjoying the mandazi. And he finished his submissions. Interesting enough? What does that tell us? It's not just about the legal jargon. It's not just about the law for you to persuade. You can look for strategies. The other side need to feel like they're connected to you. So if you feel, I'm not asking you to go with mandazis in court. What I'm telling you is this. Read the mood of the court. Read the mood of your witness. Then find ways of getting a connection so people can be interested in what you're saying. So that's another art that you need to think about if you want to persuade. I think that's enough for today. And before maybe I open the door for question, just remind me of those who have contributed. I give them something. Are you sure? I contributed. I was using the microphone. I think I remember him. Who have I forgotten? Come for it.
Okay, let's appreciate the speaker. Yes, there is one thing that I mastered, and somebody asked me, what is the JO? What is JO? So maybe Melanda, you can tell us. The judicial? Correct. Some people might be wondering, I don't know who they are. That was excellent. Thank you so much. At this juncture now, let's move to the Q&A. And I'll be inviting questions from the audience. Council will be noting them down, and then she'll be responding. Maybe we take the first three. She gives answers, because I'm also aware we are having a class at 5:30. I'll want to finish a bit earlier so that people catch up with the class, right? First question. Oh, I don't know who will help me give the microphone. Okay. We begin. Melanda, your question should be brief.
Okay, I have a couple of questions. The first one is, during examination in chief, what happens when a witness turns hostile? Because I think last week we saw a situation in the Eric Maigo murder case, the Nairobi hospital finance chief. The defendant was not supposed to plead guilty. However, when they went to court, when she was asked whether she pleads guilty or innocent, contrary to what they had agreed with the advocate, she said she pleads guilty. Let's say this was during examination in chief, and then the witness is giving evidence that is adverse to the advocate. What happens? And second, you have noted that it's important that the pleadings, what we bring out as evidence in court is what was contained in the pleadings, because the judge will counter-check. Does that mean that parties in a case are bound to their pleadings? And if not, what could be the circumstances that allow any deviation? Thank you.
Those are excellent questions. Council is taking them down. Yes, let me pick from Beryl, and then I'll go to Issa.
Good afternoon. My question is, during chief examination, and your witness states something or information that was not in the witness statement, as an advocate, do you have the right to tell the court that your witness is stating facts outside their witness statement and they want them to start again? Is that allowed? And also, in times where during cross-examination your witness or your client brings out information that you're unaware of, what is the technique or strategy to make it to come out to your favor, to show that even though you're actually not aware that this information actually existed?
Those are, I restrict to only one question. Yes. Okay, please make your second question clear.
My second question is.
You stand up. So maybe we give you some time to.
No. Yes, when your witness. Was it? Can you just give me? I think I have.
Okay, maybe we give us some time to remember the question.
Hi, everyone. So my question to you is on the proceedings. You said they were to be organized. So I've come across various witness statements, the formats. Actually, there are ones that use the block form, and the ones that use the point form. So my question is, which format is more preferable? Thank you.
Talking about formats, let me take the last set of questions.
My question is, I think this is an observation I made when I was in judicial attachment. We know that during when witnesses are testifying and you have multiple witnesses, it is advisable that the other witnesses that are testifying for one party are not within the court. And there's a case whereby a witness had testified while the other witnesses were in the same court. So, yeah, and I think the counsel for the other party did raise an objection. In such a scenario, as an advocate, whereby you have one witness and the other witnesses are in court as well, how do you end up justifying the statements of the other witnesses who are in court, given the fact that the other counsel had raised objection? Thank you.
Okay. Maybe to be fair, I'll take it in the second round. A lady, so that we balance gender. Any question from the ladies from the first round? If there is none, you want to clarify? Okay, kindly.
Okay. My question was during cross-examination, and then your client or your witness, gives information that you were not aware of from the start during even your chambers. How do you use that to come out into your favor after that? Like, what technique or strategy would you use?
Okay, allow me then give the microphone to the bench to answer, then I'll take the second round of questions.
So the first question was, if your witness turns hostile, how do you treat that witness? If a witness turns hostile, as he said, that means that the witness is giving facts that are not supporting your case. Like he's testifying on behalf of the other side. So then this witness then is subjected to cross-examination. So you turn this witness to the other side's witness. But how do you do it? You inform the court that your witness has turned hostile. Explain why you're telling the court the witness has turned hostile. And then apply to the court to declare officially that he's an hostile witness. It is the court that declares. Once the court declares that, then now you put the other hat and start cross-examining. Or if you want to take time, because remember it's an ambush, and our trial these days is not by ambush. If you want to take time to prepare your cross-examination questions for this particular witness, you also seek time. And then you'll be able now to cross-examine them instead of doing examination in chief. Then the other question was on parties being bound by their pleadings. Yes, that is the rule here. Parties are bound by their pleadings. You're not allowed to bring in things that were not in your pleadings. And that's why we encourage to understand our client's case, prepare well, and do good pleadings. Because as I said, you lose your case in chambers. So if you left out something that was important, then you cannot just ambush the other side by starting to rely on it in court. But we all know in law, there's always an exception to the general rule. And that's why the law provides for amendment of pleadings. Before pleading close, you are allowed to amend your pleadings without seeking the permission of the court. So if you realize that there's something you left out in your pleadings that it's really important, and pleadings have not closed, go ahead and amend your pleadings. But if pleadings have closed, maybe you started the trial process, but you feel that whatever amendment needs to be done or whatever you need to bring in will help the court to determine the real questions in controversy, then seek the leave of the court through a formal application to amend your pleadings and bring in what you had left out. As long as what you're bringing out will not change the whole case. It's not bringing in another cause of action altogether. Because when you're doing this formal application, by the way, it's not automatic you'll get it. That's why you really need to convince the court through this application that it's important for these pleadings to be amended for the real questions to be determined. The other side will also have a chance to respond to your application, whether it should be allowed for amendment or it should not. But in most cases, you find in such instances, the other side rarely objects because they're also given a chance to amend. Then there was a question on, I don't know whether I got this right, Beryl, examination in chief. Can they state what is not in their statement, right, when they're giving evidence? So it all boils down also to the question on being bound by pleadings. And I think I'll tie this question to one of the questions on how you're supposed to draft your witness statement, whether in point form and in block. So when you're doing your statement, most of the times you find that advocates just, for example, will just even do a one line and say, I confirm everything that is in the plaint and I will adopt that as my statement in the witness statement. That is not right. A witness statement is basically everything that your client is supposed to say in court. Everything. And in fact, our system has changed these days where your client might not even be given a chance to say anything apart from adopting their statement, where you just go there and you ask your witness whether this is the statement they signed and whether they will want to adopt that as their testimony. And the witness says yes. And most JOs these days really encourage that. In most court, that is what is done. So if you don't write down each and everything, then you lose out. So to answer this question, I will just say, when doing statements, write down each and everything that you will want your witness to say during examination in chief, and do it in an organized manner, whether in block form or point form. Just ensure you do it in chapters, or what we call headlines. Because that will also help you. If you have to go through examination in chief, it will help you, you know, this is the chapter that I'm starting with, and it's in this area of the witness statement. And you know, your witness sometimes is even allowed to have their witness statement. So if you've arranged for this witness well, they're able to know if you're asking a question, even if you decide to start with the last chapter, the witness is able to know we are now being asked questions on this particular chapter. So the most important thing is just organization, whether in block form, but have an organized structure. Then there was the question of witnesses being asked to go out, and the witness, in a scenario where the witness did not go out. Again, it's a responsibility of the advocate or the opponent side to ensure to raise that issue when you start a hearing. Alert the court that the witness of your counterpart have not gone out. Because if you don't do that, it prejudices your case. Because why is this done? Remember, some of the evidence that are given through oral testimony, there's need for collaboration. And to corroborate some of this evidence, you need 2 or 3 witnesses to corroborate. For you to persuade or to convince, you need to show that 2 or 3 witnesses are saying the same thing and the story is similar. But if your witnesses are all there, yes, it will help you, but is it helping or prejudicing the other side? Of course, it's prejudicing the other side. So it's the responsibility of the other side to tell the court, all the witnesses are in court, they need to go out. If you don't tell the court, and yes, it's also the responsibility of the court, but sometimes they do forget. But if you don't tell the court, then can you really come back later and complain about it? You can't. So I don't know whether I've answered your question. Not yet. Okay. Can you just repeat it?
For instance, I think I saw this in Kilifi, so probably there's a lot of language barrier and so before you have your first witness, especially if examination in chief, to testify and clarify that witness in this case can kindly move out, and they do forget to move out and the hearing has started. Then mid-hearing, the opposing counsel realizes your other witnesses are actually still in court. So as counsel, whereby you've already realized that some of your witnesses are still in court, what solution do you have to save your story, for instance, so that there's no prejudice in whatever the other witnesses are going to come and still say? Because I don't know, but one of the solutions I had is probably if you can adopt just the statements, and opposing counsel can use the statements of the other witnesses to probably cross-examine the witness. Or either you can, is it possible to adjourn the case to a later date so as to break that that transaction of events that is happening at the moment? I don't know what solutions can you do to save yourself from this situation.
Now, this is the advocate whose witnesses are in court, right? Okay. I think the first thing, again, it goes to professional ethics, integrity. If you as an advocate, even though they've been told to go out and they're still there, and you know that they're still there, then it's your responsibility just to actually tell the court that your witnesses are still there and request them to go out. But in a situation where you didn't know, because sometimes you actually don't know that they're still there. So they will be sitting behind and you don't know that they're still there. And of course, the opposing counsel then brings out that issue. Again, it's honesty. Of course, apologize to the court. You're not aware that they're still there. And remember also, it's not just your responsibility, so you're really not to blame also, but also the court, because it's also the responsibility of the court when the witnesses were being called to ensure that they go out. So it's a responsibility that falls both on the advocate and the court assistant who is there. So of course you do apologize for that. Try and show the court how it will not be prejudicial. Remember, you're trying to win your client's case. So try to show the court how it will not be prejudicial in any way. Because I'm looking at your solution where you say you adjourn. You adjourning is actually going to prepare them better than just proceeding, letting them go out, the ones who are not gone out, and then proceeding from there, but stating to the court that you are not aware of that position. But yes, if the court then allows for adoption of witness statement, I think that's something that can work, and I don't see any court really would object to that, because that's actually even the practice that is being done at the moment.
Thank you. I'll take the last round of questions, and if you have to ask, ensure you just stick to one question. And you're very many. Remember, we're having a class. Okay, I don't know whom to give. There is somebody that had raised a hand the very far end. Okay, please, Titus, stand up.
Yes, good evening. My name is Titus Kemala. Yes, I wanted to know, in event you're in court and your client is giving witness evidence, and along the way you realize that according to law he is in fact incriminating himself or herself. What action do you take? Do you stop him? What do you do? I seek your guidance. Thank you.
Thank you. Well noted. Any other person from this end? One question? Niliona mikono jamani. Oh, hamtaki kuuliza. Jelani?
Thank you. My question is more on procedure. So during cross-examination, and when you're asking the witness questions, they seem to be getting excessively emotional, and this could be aggressive, or maybe they've been crying. So what are we supposed to do as future counsel in that situation?
About emotions. Okay, Dan?
So during cross-examination, so let's say you're trying to bring out, let's say one of the witnesses was an engineer, so you're trying to bring out a report that they did. So how do you make sure the JOs sees this report? How do you bring it before them?
Thank you very much for this opportunity. My question is that the presentation was much about a normal court arrangement and jury, where the witnesses are present in the court, the counsels and the judge. But then we have scenarios that are unique, where you have protected witnesses that would not appear in person before the judge. So my question is, does non-verbal cues or that aspect of communication have any impact in terms of the judge making some observations that are key in the process of presentations? And in cases where the witness is protected and probably in a different setting, what are the disadvantages that may serve, especially to the side of the defense or prosecution? Thank you.
Thank you. So I have one question in regards to expert opinion. Because of the contemporary issues that we are having in our society today, where we have people who are not rather experts doing work or practicing as experts in hospitals, sadly in the legal profession, now it's outside there. Police, I remember one called Waiganjo in Nakuru. And so my client, let's say, brought a case, for example, a sexual offense case, and of course, the underlying processes happened and a report is out, which comes as an expert opinion before the court, documented. The opposing counsel bring it before the court that this expert was not indeed an expert. And definitely, that's a disadvantage to me. My question is, how do I come back? Because that's really a sweep. Thank you.
Excellent. I want to give somebody that has one burning question kindly. One burning in your ukitoka hapa kama hujasema you'll feel so bad. This side. There is none. Sawa? Okay. Melanda, you'll give me stories. Okay. But Melanda has the very last one.
I think for the sake of our other students, I would want Wahidi to speak on what if someone exercises their right to remain silent? What happens?
And also, counsel, I remember during the Supreme Court proceedings, one counsel began by singing a song that everybody remembers, the Piki Piki Ponki. Is that also a mean to persuade the court? Maybe you tell us in that line.
That must have been his theme, Piki Piki Ponki. A client who is giving evidence that he is incriminating themselves, I'll take us back. If this is your client, then you should aim not to find yourself in that particular situation. And there are ways on how you can do this. It boils down to preparation. Your client comes, gives you their story. Do pleadings, file them, and before hearing, do what is known as a pretrial briefing. Not really coaching your client on what they're going to answer, but prepare them for trial, telling them what is expected of them during the trial process. Even as much as it's their story, reminding them what their story is about and what the court wants to hear so that that story can win or can be the best story. Because if you don't prepare your client, believe me or not, they will come and say things that are prejudicial to their case. So always do a pretrial briefing. And even if you do a pretrial briefing today and the matter doesn't proceed, but you've done a very thorough pretrial briefing that you know this is going to be a good case and your client understand what is expected of them, and the matter is adjourned and your client doesn't give evidence, the next time the matter comes up, also do another pretrial briefing. Don't assume that since you did it once, it's enough. So that is what I will encourage all of us to always do before we put that client to testify, so that we don't find ourselves in those situations, unless, of course, it's a hostile witness, which is different. Emotional clients. Someone asked about emotional clients. And yes, some of these cases are emotional. These people are affected. Some questions might be asked that will make them go back to what really happened to them, like in sexual offenses case, or even assault, or even murder, someone who witnessed the murder. But as a human being, just where you are seated, even if your friend was to become emotional, what would you do? That's the question that you ask yourself. Will you just stand there? Or will you want to help? The court is also human, and the court understands. So your client breaks down. You might know your client better than the court or the opponent, and you know if this client breaks down, they might not be able to come back and we proceed well. seek leave to adjourn, or seek leave to have some time with your client outside. Because sometimes just offering an handkerchief might not be enough. So it's up to you to analyze and see whether this is something you would want to adjourn or just take some few minutes and come back. There was the, how do you bring an expert report? Remember we said we file all our witness statement and we file all our documents when you're filing your case. Witness statement are for all types of witnesses except expert witnesses. It's not mandatory to do a witness statement for an expert, because an expert is bringing in a report. And that report in itself is a statement. That is what is going to testify. So you file it in your documents, in your list and copies of documents. File it. Then when your expert comes to court, it's your expert to produce that particular report. And you use the examination in chief techniques. If this is your witness, if the expert is your witness, you use the examination in chief techniques so that the expert can talk about the report and finally produces it. In a scenario of protected witnesses, where the witnesses might not be in court, and we said sometimes demeanor is very important, goes a long way, even to you as an advocate. Sometimes it's easier to know whether the other side's witness is lying or saying the truth by how they behave, how they react to certain questions. We go back. Fair trial. In as much as this witness is protected, if you feel that this witness, you need to be there to do your examination or to examine this witness, if you know that you have good grounds to do that, apply to the court. I don't believe that in any way will interfere with the witness protection, because the court will find a way of you doing this and still the witness is protected. It's just that the online and the virtual hearings. These days, most of our cases are done virtually. But there are those cases you feel like the court will not feel you, the court will not feel your client's case well, like in land cases, and even in most of them is criminal cases. We make applications for us to be heard physically, and we go into court physically, even though the law is very clear these days that hearings are supposed to be virtually. So you can always make those applications if you have good grounds to do so. Did I finish all of them? I think the other one was an expert, which I've answered.
Just one thing about the expert witness. You know, when they get onto the stand, they have to explain themselves, where they went to school, how many years experience they have, and maybe the court might ask them a few questions in relation to that. So it will be easy to pick out that, you know, whether they are quack or not. And if you are suspicious, you know, you can always ask the court to give you time to go and get, if it's at LSK, go to the LSK portal and find out whether I'm masquerading, whether I'm in active practice, or I have a disciplinary matter, I've been suspended and I'm not supposed to, you know, practice in whatever field. Because all professional bodies have a body that, you know, registered boards. So it's always it's easy to find out. You just go in, key in their name. We all have special numbers and all those, you know, where we work, what areas we practice, and all those things. Yeah. So I think that it's easy for the court to just pick out who is masquerading and not. Yeah.
I think just to add on that and to tie in with your question, when you're dealing with an expert witness, especially if you're bringing this witness, for example, a doctor, and this is the doctor that examined your client, Don't just take the report as it is before you file it. Do that research, as Dr. Bakari has said. Actually, do the research to really find out if this is a qualified doctor and is registered before you file your documents. The same way you'll be doing on the opponent side, once they have filed their documents, then you'll be able to raise that issue. But of course, as you say, maybe you've done your research and then you're ambushed in court that this is actually not an expert or someone who is not qualified. Then what do? Will you be able to tackle it there and then? No, you may need to retrieve back to your chambers and look for a strategy on how to handle it. Let the court know it has just been brought to your attention. You need time to seek instructions from your client, because we act on instructions. And then you go back and look for the best strategy on how you'll handle that particular issue.
Counsels, you'll allow me, there is one burning question. I don't know how burning it is. Maybe let's have the pleasure to hear. Somebody just texted me and said, one burning.
Thank you very much. During the identification of the theme, you stated that I should make my case interesting. So at a personal level, I know and I presume that my case is interesting. But how can I tell that the judge or the court finds it boring? So what can help me identify that the court finds my case boring? Thank you.
She's saying interesting is a relative term. Yeah. So.
Okay. One of the things that you do when you're submitting, look at the judge, what the judge is doing. I'm sure if you've gone to court sometimes, you find that counsel is submitting and the judge is not even writing. Ask yourself, if you notice that, ask yourself why the judge is not writing. There's one senior advocate that I really admire in Mombasa, and I'll not mention name. Every time he notices a judge not writing, he asks the judge, did you miss that? I see you're not writing. Yes. And you see, just the way you just laughed, you get the judge's attention. But interesting, it's not just about what you're submitting on, but even how you've prepared. Interesting boils down also to organization, using the rule of primacy and recency. Starting strong and ending strong. That's interesting. Don't start strong and then you don't end strong. It doesn't become interesting. It doesn't become persuasive. Rhetorical questions make submissions interesting. Being sarcastic at some point makes it interesting. Repeating sometimes makes it interesting. Pausing when you have a strong point that you want the judge so that it can sink in. Using nonverbal communication. You see, like what I did, I want it to sink in. That makes it interesting. So all those techniques can make your case interesting. Or rather, the story that you're telling, interesting.
Okay, that brings us to the very end of our questions. And at this juncture, maybe to allow Dr. Mwanakitina just make a general comment, and then I'll be asking Thomas Mlanda to do a vote of thanks, and probably we'll actually have announcements, then a vote of thanks, and probably we'll have a moment to have, is it called pictures? Am I in photo shoot? Which one is it? Okay, photo moment. Thank you for the correction. Dr. Just a general comment.
Okay, I think what is key out of all this is the preparation. The whole court process is preparation, how you prepare from the beginning all the way to the end. Take note of, be keen on details, documents that you receive, verify them, read your pleadings, respond to any allegation that is made. Don't just assume that it's a small thing. Pleadings are very important. That's why you're saying, when you're listening to your client's story, be keen. ask questions, interrogate. Because sometimes clients are not very honest. Yeah, so they might tell you something, and then when you get the response, you realize, the new facts come about. So it'll force you now to go back and amend and again, do research and everything. So I think preparation is key. Be patient. I think when you're litigating, you also have to be very patient, because sometimes your opponent can be very aggressive. Your client can be aggressive. That's why sometimes you have hostile clients. You're trying to lead them to say something, and they're insisting they want to say something else. So, you have to think on your feet. Yeah, so there are always surprises in court. No matter how much you prepare, there'll always be that one moment that will just be like, oops. You're like, you didn't expect that. You're like, oh my God. So you have to, just come back to your lane and think straight, Yeah, that's why they say lawyers have to think on our feet. That is exactly what you do, because it's like somebody has just thrown you off, especially when it comes to cross-examination. That's when we get lots of surprises. You're like, oh, I don't know how my client is going to handle that, So at some moments you feel like you want to go to the stand and and answer those questions. Yeah, so thank you very much, Lillian, for that insight. As always, it's a pleasure to have you, and we appreciate your time and expertise. Thank you very much.
Okay, let's appreciate Dr. Maybe you allow me just give announcements. One, we are very glad that our students, that is Precious and Jasmine, and they had traveled to Eldoret for a moot competition, and we are glad to report that they are the first runners-up. So that is the efforts of Daktari and Cancer, because she's been with us for quite some time. We've walked a long journey when it comes to moots. What LSAC does, we intend to work collaboratively with the mooting club to ensure that we restore the vibrancy and to ensure that the students get that exposure before we get into the actual field of practice. So that is number one. We are very glad they're at least coming with something, right? Other than that, we also intend to have a moot competition, which things are still underway. We are planning. And at any given time when we ask you to join, we intend that at least all cohorts be represented, beginning from first year to the very fourth year class, so that at least we get to learn from one another. So once that one will be out, we'll be sharing in our walls. We invite you to be part and parcel of that. I understand sometimes we have some little bit of budget constraints, because when you gather people here, people watakuuliza SG bwana umetuletea nini? But don't mind, everything is under control. So in the next events, utakuwa na kitu hapo kwa meza, at least when you're listening, you are listening na tumbo pia iko sawa, sio? I understand. That is obvious. Human nature. I don't want to belabor so much. Allow me welcome Landa to give a vote of thanks. And then the very last person that will do a closing prayer from a Muslim. I believe we began with a Christian, so we'll have a Muslim. Sheikha will help us do that. Thank you.
Thank you so much, Titus. Thank you so much, Dr. Mwanakitina, and also Counsel Lillian Oloch. As I said earlier, for those of us who've been taught by Dr. Mwanakitina evidence law, we can attest to just how much we all enjoyed it and deeply learned it. Because for us in our class, we will never forget that she gave us individual feedback that really made us grow. We really appreciate that. And when I went on my attachment, whereby I was stationed at the High Court Civil Division, Justice Magare Kizito made a note that indeed evidence law is something every lawyer has to master, because it cuts across all areas. In fact, he did mention that while our first Bible is the Constitution of Kenya, the second one is the Evidence Act. So I believe we're in proper hands, and every time it's always a pleasure to be able to learn. I would like to extend also my appreciation to the students for being able to turn out in large numbers. We've had a full house, so please give a round of applause to yourself. And finally, kindly allow me to welcome a colleague who is an elder brother. He's a classmate, but he's also a priest who has been able to ensure so many of the things in the background preparation have been able to run. Father Bosco, maybe you may say hi. Okay, so this is Father Bosco. He's in charge of Miritini Catholic Church, but he's also a classmate and an elder brother. So thank you so much. We look forward to so much more engagements, which will enrich all of us. Let us be able to engage and learn from one another. And I'm so glad that our administration have an open door policy where anytime we can always approach them and be able to learn as much as possible. So thank you so much. Until next time, see you. Father Bosco?
Good evening. All protocols observed. Today is a day that is meant for other peoples to be having the stage. So mine is just to congratulate each one of us and to hope and pray that we're going to have more of these sessions. Asante nyote organizers and all those who are present here.
Thank you so much, Father. Let's have someone to close for us with a word of prayer. A Muslim. Sarah Bajapir. Nawaila. Nawaila is here. Please pray for us, Nawaila.
Good afternoon. Let's all pray Surah Fatiha, please. Thank you. Maybe I can assist Noel. She did it silently. We do that. اللهم صل وسلم على سيدنا محمد. اللهم بارك جمعنا هذا. Oh Allah, bless this union of ours, increase us in knowledge and wisdom and wealth. Ameen.
Oh, there is only one event that is remaining and I'm waiting for Dan to come. But at the meantime, I don't know how we are going to do the photo what? Photo moment. You know, I forget that. I wanted to say photo shoot. Photo moment. Please, and just an announcement. I'm waiting for Dan. The event was live on YouTube, and in our different walls we can share. Sorry? Yeah, you can share. Okay, Dan, guide us. Okay, now Dan, guide us through the next
section. Let's be silent. Let's be silent, kindly. So right about now, I would like to invite our guest, Madam Lillian. We have a token of appreciation for the work she has done for us. I hope most of us have benefited, right? So I will bring Mursal. He will award Lillian Oluoch a small token of appreciation. And we will have a photo session for this too. Thank you. So I will return the mic back to the moderator.
We're actually done. Maybe now the photo session, you guide us how we'll do it. But how I wish we are all there, because this is a law students, right? Si mawakili mchukue flow sasa tupige picha, and then we live at our own pleasure. Oh, you want to say something?
Yeah. Can I? In front of me. With the mic. I'm talking. Wait.
Hello. 1 minute of
Hello,
one
excuse
minute,
me, so that we save time because there are classes.
There's a small announcement.
Excuse a moment, please. Silence. One moment.
We have a small announcement, please. Okay, Madam Lillian wants to say something to you.
Okay.
Mine is just to say thank you so much. I really appreciate every time I come here. I also go having learned something. So it's always good to share with you the knowledge that I have. And with that, I just want to extend an invitation to all of you. Those of you who've heard of Justice Advocacy Africa, that sometimes partners with Mombasa Law Society, the Trial Advocacy Training Institute in Nairobi, we are having a webinar on the art of persuasion. This is a webinar that will be headed by the President of Justice Advocacy Africa, Steve Fury, who is in the state. And we'll have all the 4 countries. Yours truly, Lillian, will be representing Kenya. We have one from Botswana and Malawi and Uganda. It will be online on the 16th of November. I think Dan is one of our alumni and also Father Bosco, if I'm not wrong. So they will share the link with you. Please register and join. You'll learn a lot from there and even know about how the other jurisdictions do it.
Okay. I request kindly we come in front here so that we take one picture here.
I can share the same on the on the class reps wall, and then you can share with the rest.
Go up. Thomas, you did.
No, we are coming.
Let's save time, please. We move in front. Thank you. Kiongozi. Wait, panda.
Pandeni juu mpige picha. Acha niwapige picha.
Hello, let's save time. Excuse me, Mlanda, let's save time. Mlanda, let's save on time, please. Join us. Join. Hello. Okay, please join us. Excuse me, let's cooperate. We save on time to ruhusu wageni wetu waondoke. Everybody. Oh. Chelsea, please join us. Oya Mursali, join us. No, we can even stand here. It's enough.